May it please the Court, in the case of New York State Rifle and Pistol Association v. Bruin, myself, Lucia Zhang, and my co-counsel, Devin Von Arks, will be representing the petitioners in today's case. The question presented before us is whether the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense.
Our case today is that the decision should be overturned because the text of the Second Amendment, along with history, tradition, and precedent, protect the right to keep and bear arms outside the home for self-defense. District of Columbia v. Heller recognizes that the text of the Second Amendment establishes an individual right to not only keep arms, but to also bear them for the core lawful purpose of self-defense. Such a right dates back to the English Bill of Rights and the Blackstone Doctrine, which influenced the creation of the United States Constitution. Previous Supreme Court cases, such as United States v. Miller, D.C. v. Heller, McDonald v. Chicago, and Catano v. Massachusetts, reaffirm the right to self-defense as central to the Second Amendment, and citizens must be allowed to carry arms for traditionally lawful purposes. Carrying a handgun outside the home for self-defense is well within tradition. Although Heller did not establish a level of scrutiny to evaluate Second Amendment restrictions under, the court ruled out rational basis review. However, the Sullivan Act fails under both strict and intermediate scrutiny because the New York government has failed to provide proof that their licensing law is narrowly tailored or substantially related to achieving their objective of increasing public safety. Further, the Sullivan Act is both vague and subject to arbitrary enforcement. As a result, both the vagueness doctrine and the 14th Amendment's Equal Protection Clause should cause the law to be revoked. A law that is unequally applied is prima facie an unjust and unenforceable law.
What does the Second Amendment protect?
The Second Amendment states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We agree with the interpretation in D.C. v. Heller, where the court states that the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes. While Heller applies such an interpretation to within the home, Heller does not limit such a right to just the home. As demonstrated by history and tradition, carrying arms for outside the home for self-defense is considered a traditionally lawful purpose. McDonald v. City of Chicago and Catano v. Massachusetts reaffirm Heller's decision, confirming that the inherent right of self-defense is central to the Second Amendment right. If the right to carry arms outside the home was not protected by the Second Amendment, it would not have been sensible for the court to reverse the Massachusetts Supreme Judicial Court's decision in Catano, considering she was publicly carrying her stun gun. Thus, the Second Amendment confers a right not only to keep arms at home, but also to bear arms outside the home for the core purpose of self-defense.
Why did the framers include the Second Amendment in the Bill of Rights?
The framers thought that governments used soldiers mainly to oppress people. Unless America was facing foreign adversaries, ordinary civilians carrying weapons and militias should be used instead. However, during the era of the Articles of Confederation, militias proved insufficient, and so the framers wanted the new federal government to have the ability to have a standing army even during peacetime. Some people, though, feared this gave the central government too much power. So, James Madison suggested the Second Amendment, a way to empower the state militias. As the Heller decision put it, it is entirely sensible that the Second Amendment's prefatory clause announces the purpose for which the right was codified, to prevent the elimination of the militia.
What are the limits of the Second Amendment's protection?
We agree with Heller's interpretation that there should be no doubt on long-standing prohibitions of firearms or laws forbidding the carrying of firearms in sensitive places. However, we strongly hold that these limitations on Second Amendment protections should satisfy means and scrutiny and a unique vulnerability standard. While we have no interest in litigating how to determine what constitutes a sensitive place exactly, as that is not relevant to the current matter, we can propose a rough standard of unique vulnerability. Unique vulnerability means a uniquely vulnerable population, places where guns present a unique danger, or places where a gun poses a unique threat. The burden of proof on the validity of these regulations would fall on the government. The New York licensing law does not satisfy these requirements because it does not satisfy means and scrutiny. Thus, this limitation is unconstitutional.
What weapons does the term arms include?
Arms is defined as a weapon, and it does not need to be specifically designed for military use or employed in a military capacity. This is the same as the 18th century definition that holds true today, which is indicated by Samuel Johnson's definition of arms as weapons of offense or armor of defense. This does not include a short-barreled shotgun, for example, which demonstrates that the Second Amendment not only extends to certain types of weapons. However, these arms are not confined to just what was present at the time of founding. As supported by Catano v. Massachusetts and Heller, stun guns, a modern weapon, are included. And, in this case, handguns, which are the most preferred firearm in the nation to carry for their Second Amendment right.
What is the difference, if any, between the verbs keep and bear?
When looking at the definition of the two words, we follow Heller in the understanding that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary, as distinguished from technical meaning. To do so, we turn to dictionaries from the time of the Constitution, which illustrate a key difference between the two verbs. As supported by William Blackstone and Hawkins' treatise of pleas of the Crown cited in Heller, keep arms was a common way to refer to possessing arms for militiamen and everyone else. On the other hand, bear meant to carry, an interpretation supported by Samuel Johnson's dictionary, the 1828 American Dictionary of the English Language, and the Oxford English Dictionary. Both Johnson and Webster provided examples of bear arms and a coat being a garment typically worn outside. As Heller stated, bear has a meaning that refers to caring for a particular purpose, confrontation, and such confrontation often occurs in the public. If keep means a right that is limited within the home, it would have been redundant to include a right to bear arms that was also limited to within the home. Therefore, the Second Amendment right to carry arms for self-defense clearly extends beyond the home, and confining the right to within the home would conflict directly with the text.
What is a militia, and why did the framers refer to it in the Second Amendment?
Adam Smith's Wealth of Nation, written in 1776, defined militia as the state may oblige either all the citizens of the military age or a certain number of them to join in some measure the trade of a soldier to whatever other trade or profession they may happen to carry on. Its military force is then said to consist in a militia. The Founding Fathers had just seen a militia topple a great military power. They understood that a militia, common people bearing arms voluntarily, can bring immense power. Having all the citizens able to bear arms and become an instant militia prevents tyranny. As James Madison put it in Federalist 46, besides the advantage of being armed, which the Americans possess over the people of almost every other nation, forms a barrier against the enterprises of ambition, more insurmountable than any which a simple government of any form can admit of. By referencing to a militia in the Second Amendment, the framers codified the right to a militia.
How should courts determine if a gun control regulation is considered long-standing?
Gun control regulation is no different from any other type of regulation. Thus, the determination of long-standing is the same for any and all regulations. The first part of the determination is obvious. A long-standing regulation should have been in place for a long time. While there is no agreed upon exact number, we believe 1 generation, or 25 years, is a reasonable start to the definition. More important to the definition is that a regulation should be considered long-standing if it has come to be something that people rely on, that they have modeled their behavior on. For instance, Roe v. Wade, a law for 48 years, is long-standing as women have come to rely and expect access to abortion. So, consistency of use over a long period of time would constitute long-standing. However, as the Roe example demonstrates, just because something is long-standing does not mean that it cannot be altered. There are many long-standing traditions which have proven to be based on incorrect understandings and have needed such alteration. Plessy v. Ferguson created a system of inequality, which remained a long-standing way of life for Americans for 58 years until it was rightfully overturned by Brown v. Board of Education in 1954. In an effort to not destabilize society, long-standing laws should not be dismissed arbitrarily, but that does not mean that they should never be altered.
What is strict scrutiny, intermediate scrutiny, rational basis review?
Scrutiny determines how a court will determine the constitutionality of certain laws. Strict scrutiny, partially articulated in Skinner v. Oklahoma, requires the government to prove that there is a compelling state interest behind the policy on trial, and that the law or regulation is narrowly tailored to achieve its results. Intermediate scrutiny, as created in Craig v. Boren, requires the government to prove the law serves an important government objective and be substantially related to achieving the objective. It differs from strict scrutiny in that it applies to issues such as gender discrimination, which is a less protected group than race. Finally, rational basis review, created by the court in Nebbia v. New York, shifts the burden of proof from the government to the plaintiff. The person challenging the law must prove that the government has no legitimate interest in the law or policy, or that there is no reasonable, rational link between the interest and the challenged law. District of Columbia v. Heller determined that Second Amendment cases should not be ruled under rational basis review. However, the court neglected to clarify if these cases should be assessed under strict scrutiny or intermediate scrutiny. Under both intermediate and strict scrutiny, the law does not satisfy scrutiny.
Is there a difference between openly carrying a firearm and concealed carrying a firearm?
There should be no difference between open and concealed carry beyond the obvious visibility of the weapon. The Second Amendment, which enshrines the right to self-defense, makes no mention of open or concealed carry, but just guarantees the right to carry. We have no problems with New York restricting open carry. States can determine if they want to allow open carry, concealed carry, or some combination of the two. What they cannot do is place unconstitutional restrictions on both, which is our issue with the New York law also restricting concealed carry.
How should the court consider the public safety implications of licenses to carry firearms?
It is necessary for the court to balance public safety implications against the Second Amendment right. The impact of stricter licensing regulations on public safety is crucial when considering whether or not the law satisfies means-end scrutiny. Unfortunately, no conclusion about the correlation, much less causation, between the two can be drawn. The National Research Council and Community Prevention Services Task Force conducted reviews on the scientific literature on the effects of gun policy. The two reviews reached nearly identical conclusions. The evidence was insufficient, and none of the different arguments were convincing. Additionally, license holders are overwhelmingly law-abiding citizens. The Violence Policy Center's data demonstrated that America's 18 million concealed carry permit holders accounted for only 801 firearm-related homicides over a 15-year span, roughly 0.7% of all firearm-related homicides during that time. Because the New York government is unable to definitively prove positive public safety implications tied to the licensing regulations, the court should consider public safety implications, but also heavily weigh the Second Amendment right when considering the New York licensing regulations.
Thus, we believe that this court should reverse. Thank you.
Thank you.